Hello, my name is Professor Graham Williams and I'm here today to talk to you about being an expert witness. So who am I and why am I here talking to you about it? Well, I'm a forensic biologist and I've been there, done that. And so I am an expert witness myself. And so what I'm here today to talk to you about what it means to be an expert witness and how that impacts on becoming a forensic scientist or a forensic investigator. If you have any questions you want to ask me at all, you can just email me at graham.williams@staff.at.uk. So, first thing is, what is an expert witness? In the eyes of the law, in other words, the courts, an expert witness is someone who is recognised as being an expert in their field and is therefore allowed to give their opinion. And it's that key thing that makes the difference between a witness and an expert witness is the ability to give an opinion. One of the misconceptions about being an expert witness is people who think they're an expert in something, whether they are or not, they can give evidence. So if I would say I'm an expert in Star Wars, for example, I can give evidence on Star Wars. That is a kind of a misunderstanding of the term. So what it is someone who's been recognised by the court as having a thorough understanding of that issue in question, and then being aware of the limitations. And I think one of the things I like to say about being an expert witness is the ability to recognise what you don't know. It's about knowing your limitations. So I can comment confidently on this, but what I can't talk about is this, for example, and I know not to stray into that area. And I think that's the key thing what makes an expert witness. So the emphasis really here is on witness. So you think about an expert witness is someone who's a very good witness. It's not necessarily about the expert bit. Okay? So that's the crucial difference. So an expert witness is someone who knows their field and is qualified and recognised by the court to give their opinion on that matter, and they know their limitations, and it's a very, very specific field. So what's the difference between a forensic scientist and an expert witness? You don't have to be a forensic scientist to be an expert witness, and you don't have to be an expert witness to be a forensic scientist. There are two different roles, but obviously they overlap. So anyone working in the forensic sciences can be called a forensic scientist. So for example, as a CSI or crime scene investigators, forensic examiners in the lab, analysts, they are all forensic scientists, but they're not necessarily expert witnesses. So the expert witness forensic scientist is called the reporting officer or the reporting manager. So they're someone who reports the evidence. So CSI, forensic examiners and analysts are examples of forensic scientists who are not expert witnesses. So that's where that comes from. So you can be an expert witness, but you don't have to be a forensic scientist either. And that's with someone like an accountant. So you're a forensic accountant, that's not a scientist. They can be an expert witness as well. So as I said before, fundamentally the difference between an expert witness and say a normal witness is the ability to give an opinion. So if you're a witness to a crime and you're given evidence in court, you can only talk about your direct observation. So you can only say, I saw this person do this. You can't say, in my opinion, this person did that, because that's not what they're asking you for. Okay? So if you're a witness, it's factual information of which you have direct knowledge. If you are employed in the forensics, so for example, a crime scene investigator, forensic examiner, forensic investigator, and you're required to give evidence, what you tend to be called is a professional witness. And a professional witness is just a witness, but someone who's employed to give evidence, but not necessarily an expert opinion. So it's a kind of subtle but significant differences. So the expert witnesses can give opinion provided that they are transparent and justifiable. So I can say, in my opinion, this person came into contact with this person because there is fibres found, there is fingerprints found, there is DNA found. So I can say I came to this opinion or I came to this conclusion because of the science and because of all the information behind it. So that was crucial. So that's transparent. You can't just say, in my opinion, he did it because I'm a forensic scientist. That's not good enough. So it's about being able to explore and justify your opinion in that matter. So one of the things about being a witness or an expert witness is you generally have to write a statement. So if you're a witness to a crime, the police would normally come round to you and work with you to produce a witness statement, and you'd be putting forward your facts. If you're an expert witness, you would then produce an expert witness statement. Now, prior to 2005, the witness statement template, so it had the witness statement across the top, it had that sort of legal blurb across the top. It said, I promise everything I say is the truth, and if I tell a lie, I go to prison, that kind of thing. But since 2005, expert witnesses now have to confirm that they understand their obligation. So I understand my duties of revelation, I understand my duties regarding disclosure, I understand the limitations of my field, and I have to declare that. And then in my witness statement, I have to have certain format, and that makes an expert witness statement. So witness, if you're a professional witness, you use a standard witness statement template. If you're an expert witness, you have to use a different template. Now, the thing about witnesses, so obviously we produce a witness statement. That witness statement can then go to court. And so both witnesses and expert witnesses can be required to give evidence in court. Although generally what tends to happen is you've got a statement, if the prosecution is happy with your statement and the defence is happy with your statement and they accept your evidence, you generally don't need to turn up. And what they do, they just read your statement out in court. So it's one of the reasons why you have to be careful with how you write it. If you're not there to contextualise your witness statement, then you might have a problem. So your witness statement has got to be standalone. So your witness statement can be read out loud in court in a monotone voice and not be taken out of context, and that's great. However, if they want to challenge your evidence, so for example, if the prosecution is happy with your evidence, but the defence side is not, they want to challenge you. And so what you can then do, if they'll call you, if your friend is scientist who's a non-expert witness or a professional witness, you can still be called to give evidence. So just because you're not an expert witness didn't mean that you're immune from being called to give evidence. It just means that you just have to be factual. I took this sample, I put it in the machine, this is the result that came out. Then instead, what did that result mean? That's when you start getting to the expert realms. And so you just have to be factual with what you've done. I packaged this item is then handed over to this person on such a date and time. It's all very factual. But you can still give evidence in that nature. So one of the questions people have about when I talk about giving evidence, so as someone who's been a forensic scientist working for the Forensic Science Service, and as someone who since continued with cases in the defence sector, I don't give evidence that much. So you certainly won't be required to give evidence in every case, absolutely not, because you might have a witness statement, it might support the defence. So your witness statement might say, the DNA profile did not match that person, therefore that person could be eliminated. That won't go any further, or it shouldn't do. If it does go to the Crown Prosecution Service, they might decide not to charge. It's not enough evidence or it's not in public interest. By the time it gets to court, the person who's been arrested and been charged may have pled guilty. So if they pled guilty, then obviously it won't be going to trial. So most of my cases, I've never been called to for various reasons. One, my evidence wasn't required. My evidence wasn't substantive enough, the person pled guilty, or my evidence was accepted by the court and said, we're happy with this evidence, we don't want to challenge it. So personally, about 1% of my cases ended up with me giving evidence, and most of my evidence, which is predominantly DNA profiling, was just being accepted by the court or simply read out in absentia. So how frequent you go and give evidence and so on depends on the complexity of the case. So if you're someone who deals with complex murders all the time, you're probably going to end up going to court a lot more. But if you deal with a range of cases as I did, so I did deal with burglaries, mugging, through to sexual assault, and I had some murders and terrorism cases, then some I will be required, some I won't. So they must depend on your evidence type. So you get called to give evidence, so what happens? Well, normally you get given a date. So when your case is being submitted to the court, you'll get a letter saying you're a witness, you'll be required to give evidence, please keep these 2 weeks free. And as you get closer to the time, you'll get told what day to turn up on. So you then turn up to court, and usually you have lots of waiting. For me, this is the worst part. So I'm waiting in the courtroom or in the courthouse. I'm not in the room yet. And I'm waiting in the canteen, or I'm waiting in the witness room, or I'm waiting out in the public area. And I'm waiting. But one of the things you can't do, you can't just start striking up a conversation with other people, because they might be witnesses in the same case. They could even be the defendant. It could be defendant's friends and family. And that kind of, so you've got to be really careful. They've got to keep this out to yourself. So normally go to court, just take a book with you. And I read through an entire Harry Potter book waiting in court one time. With great use of my time. It was just simply waiting. I never ended up giving evidence, but I managed to get through a Harry Potter book, and that was me waiting in court. So you're waiting. Then what then happened is you generally know when you're about to be called, and you go to stand outside the courtroom. Then the usher, normally just wearing a plain black robe, will come in, call your name. You walk into the courtroom, where all the eyes are on you, so it can be a little bit nerve-wracking. And then you have to swear an oath or do an affirmation. So, and that is basically you saying you promise to tell the truth, the whole truth, and nothing but the truth, that kind of thing. So once you've done that, then what you start off with is the evidence in chief. So if you're a prosecution forensic scientist, or you've been instructed by the police, you will generally give evidence first. So they will ask you questions, and they'll take you through your statement. So what's your name, what's your qualification, what item did you examine, what were your findings, what were your conclusions. So that's fairly straightforward. They're just taking through your witness statement. They might ask you some more complicated questions. So for example, if they think the defendant is going to challenge this particular evidence, they'll ask you lots of questions about that to try and get ahead of the curve. So that's one side. And then what happens then is you have the other person ask you questions. So the prosecution barrister asks you questions first, then the defence barrister will start to ask you questions. And that defence barrister asking you a question is a cross-examination. That tends to be a bit more probing. They're the ones that are trying to strip you up a little bit, trying to find the holes in your witness statement, trying to find holes in the science, trying to find holes in the continuity. There can be different approaches. Generally, these can be quite predictable. So generally, whenever I go to give evidence, what's been at issue is the information that I've had. So in my discipline, which is DNA profiling, body fluids, forensic biology, it's very context sensitive. So the information I have can change the strength of the evidence. And so what happened in court, they said, what if this has happened, or what if that has happened? And then I have to kind of say, well, actually, I can't really speculate. If you can give me a very specific scenario, I can evaluate my evidence. So that tends to be what happened to me. But other people in different evidence types, it might be more about the continuity, or it might be more about the science. So if you're in a more specialised discipline, I'm not going to name any, but if you're in a more specialised discipline where the science and the validations and everything is not so robust, they might try to challenge the science or the validity of your discipline. So there's different approaches. And then once the defence is finished questioning you, either you'll be accused there and then, or the prosecution will give you a chance to have a rebuttal. And what they might do is the defence might have muddied the water. So what the prosecution can do is just try to clarify things, and so they can say something along the lines of, so just given everything that my colleague has stated, have your conclusions changed? And I say, no. So could you just reiterate for the jury what your conclusions were? And you can just get through and just make it clear what's being said. And then once all that's finished, the judge will excuse you, or one of the barristers will say, you can leave now. And the coupons always wait until they've excused you. Even if you're just standing there, but sometimes they might forget about you, that you're there, then they look up and, oh, sorry, you can go. But you always wait to be excused. Because what can happen sometimes is the judge might want to ask some questions. So the judge might just say, I'm not very clear on this point. Or the judge might want to take the opportunity to clarify something to the jury. And you kind of want to be there for that in case the judge didn't explain it well. And so obviously you won't interrupt the judge, you just tell the barrister later on that it didn't really make it clear, but you need to wait to be excused before you leave. So we always have these people sort of leaving when they shouldn't do, and they say, oh, come back. It didn't really look good. And then, sometimes when you give evidence, people are always asking, what was the verdict? The verdict is irrelevant to a forensic scientist. I don't want to know what the verdict is. In all the cases I've given evidence, in fact, in all of my cases, I don't know what the verdict is. I've known maybe one or two just by accident where the police have told me or something like that. Or what happened is I know they pled guilty. They haven't been found guilty. They pled guilty. So I've gone to court ready to give evidence. Then at the last minute, they changed their plea to guilty. That's when I know of the verdict. But I would never want to hang around and see the jury deliberation. I don't want to be in the courtroom when they read out the verdict. And the reason for that is I'm not interested in the verdict. I'm interested in my evidence. My job is not to determine guilt or innocence. The moment I start taking an interest in whether that person's guilty or not, I become prosecution biased. If I start saying guilty, yes, that is so bad for offender scientists to have. I've got to be impartial. It's not my job to determine guilt or innocence. It's my job to present the evidence as robustly as I can. So if my evidence is accepted by the court, then that's my job done. If that person found guilty or not guilty, that's irrelevant to me. If I start thinking good, yeah, guilty, yes, innocent, oh no, I've done it wrong, that's not impartial. All my findings are completely biased then. So I kind of need to be careful. I'm not interested in the verdict. So I remember the first time I gave evidence, I came back and I gave evidence. I told my parents and all my friends and family that I've given evidence for the first time. And that, oh right, Dave, is he guilty then? I went, I don't know. I'm not interested. So it's just so it comes to bear in mind. It's not relevant to us. Now, this is the key point that people have. So I've been talking about giving evidence in court. For those of you who are watching this video, I bet some of you, if not all of you, are going to feel some sort of anxiety, thinking, oh, I don't really want to do this. No, it's all kind of scary. Can I be the non-expert witness? I was the same. And even that, it's not the favourite part of my job. It is something that stresses me out, it makes me a bit anxious. But that's a good thing, because if I'm anxious, I'm on my toes. My head's in the game. I focus. If I've said, I could be fine, it could be straightforward, I'm being blasé, that's when I make mistakes. Being anxious is good. Being a bit scared, being a bit nervous, it's good. It keeps you on your toes. It gives you that edge. That makes you focus on the case, make sure that you're prepared. And one of the most stressful parts of being a offender scientist is giving evidence. So people think, oh, it's working in the lab, it's working on the crime scene, dealing with dead bodies, dealing with gore. That's the easy bit. The hard bit is giving evidence. And it's very much anxiety inducing. I'm right there with you. It scares me even now. If someone said to me I've got to go to court tomorrow, I'm not going to sleep tonight. And the problem is, the biggest source of the anxiety is not knowing what's going to be asked. However, the questions are largely predictable. So when you've got the prosecution is taking you through your witness statement. So what did you do then? What did you find? Or what happened next? That's straightforward. So the prosecution side of things is easy. The defence side of things is where it's a little bit more, you have to think on your feet a bit more. And actually, it gets quite interesting. So if they come up with some really good questions that really make you think, I quite enjoy that. You kind of sit in there going, ooh, that's a good question. Just let me have to think about that one. So you're in the witness box. Everyone's staring at you while you're kind of going, thinking. And that's quite good. That's quite exciting. So kind of a good thing to do, but it is a bit scary. It is one really makes your heart pound. So we can help you with that. So if you come onto this course, we help you with how to give evidence and how to manage that anxiety, how to make it a more enjoyable experience. Now, if you're in a job that you want to do, like forensic, you've got to enjoy it. And we help you with that. So one of the things I do, if I'm going to give evidence or gone well, I symbolically take my tie off as soon as I leave the courthouse, go straight to the pub, have a pint, go home and have a takeaway. And that's how I mark giving evidence. So I kind of look forward to that. Symbolic taking my tie off, having a pint, having a takeaway. That works for me. Obviously we need to find what works for you, but that's something that we can help with. And then finally, when it comes to giving evidence, the transferable skills you get from learning how to give evidence as an expert witness is significant. First one, as expert witness, you have to produce expert witness statements which have to comply with some legislation, specifically Annex K of the Crown Prosecution Service Disclosure Manual. And this is something that you will learn about. And so this means that you've got to write your witness statement that complied with the law. And so being able to produce those legally compliant reports means you have experience of producing reports of a high standard, of a high quality. And that's something that a lot of employers like, not just in forensic, but in the non-forensic sector as well. And then having confident presentations. If you can give evidence in court for half an hour, 40 minutes, then being asked to stand up in a room full of 5 or 6 people and talk 10 minutes about a subject with maybe a couple of questions. Yeah, it's a walk in the park, it's a breeze. So when I started working for Forensic Science Service, the idea of me standing up and talking in front of people, even as a lecturer, was terrifying. But as I gave evidence, it came relaxing. Now I lecture all the time. I lecture in front of hundreds of people. I presented in front of thousands of people. It doesn't fill me with that fear anymore because I've given evidence in court. Everything else after that is so easy. So after you've done this, when somebody asks you, can you do a 10-minute presentation? Yeah, fine, no problem. So that's a really good thing to have. And a lot of people who go into the working world don't have that. So if you come onto this course and you do this course, you will. You'll have that confidence to project and get across to you. And that's something that we teach you. And it's really invaluable skill to have. And finally, it's the ability to think on your feet. It's the ability to ask someone to ask you a question and you thinking about the answer there and then. So I had a question and given evidence that, say, Mr. Williams, this was before I got my PhD in professorship. So Mr. Williams, how much does DNA stick to chewing gum? And that completely blew me. There was no chewing gum involved in the case. I said, okay. Well, now thinking about chewing gum is quite sticky, so I imagine some DNA would be retained. But the problem then is how do we get the DNA out of the chewing gum? And so that was the sort of rumination that I had on the witness stand. And which basically ended up me saying, I don't know. But they saw where the issues were. And so that kind of thinking comes on, I quite like that. So that being asked that question and answering that question, trying to come up with the answer. So if I don't know, I can try and work it out. And so I quite enjoyed that element of it. But that again is something very useful to have. So if someone comes to you with a problem, you come up with a solution. It may not be the right solution, but it's a solution, and that's better than nothing. And that's something that you get from this. And finally, to summarise, not every forensic scientist becomes or wants to become an expert witness. So this is not something that appeals to you. That's okay. There are plenty of routes in forensic where you don't need to. So becoming a crime scene investigator, forensic examiner, forensic investigator, although you will be required to give evidence occasionally, it won't be the expert witness. It won't be at the standard and the challenge that you have of an expert witness. So what you'd be is a professional witness instead, and you get training on that as well. And finally, being an expert witness is about being a good witness, not necessarily about being an expert. It's just about knowing what you can and cannot talk about. Okay, and I'm going to finish it there. So thank you for your time. I hope you've learned something. I hope you've been reassured about the whole given evidence thing. And as I said at the beginning, if you have any questions or any comments about this whatsoever, just drop me an email and I'll be delighted to reply back to you as soon as I can. Thank you very much and goodbye.